Good morning, everyone, and welcome to today's webinar on understanding the new rules for pension fund administrators, the FSCA's Conduct Standard 2 of 2025. My name is Wayne Hiller van Rensburg, and joining me today is my colleague Geraldine Fowler. We're both from the Institute of Retirement Funds Africa. I'm the executive officer, and Geraldine is the chairperson and president. Thank you for joining us today. We have a very important topic to cover, one that will significantly impact how pension fund administrators operate in South Africa. Before we begin, let me quickly cover some housekeeping items. This webinar will last approximately 60 to 75 minutes, including time for question and discussion at the end. Please feel free to submit your questions in the chat box at any time during the presentation. We'll address as many of these as possible during the Q&A session. The session will be recorded and will be made available to all registered participants after the webinar. The slides you see today are designed to be information-rich resources that you can refer back to after the session. Geraldine and I will be taking you through different aspects of the different sections of the presentation. Apologies. Sharing our insights and expertise on this critical new regulatory framework. Now, let's get started. Let me begin by telling you a bit about the IRFA and why we are here hosting the webinar. The Institute of Retirement Funds Africa is committed to making important regulatory information as accessible as possible for all stakeholders in the South African retirement sector. We believe that informed stakeholders lead to better outcomes for pension fund members and people whose financial futures depend on the decisions we make. The IRFA played an active role in the consultation process that led to this conduct standard. We submitted detailed feedback on behalf of the industry, and we are pleased to see that many of our concerns were addressed in the final version. Today, Geraldine and I want to share that knowledge with you. Our mission is simple: to support trustees, administrators, and service providers in general in navigating the complex regulatory environment so that pension fund members receive the best possible service and protection. With this context in mind, let's dive into the substance of today's webinar. I'll now hand over to Geraldine to discuss why this change was needed.
Thank you, Wayne, and morning, everyone, from my side also. So let's start with the fundamental question. Why did we need a new conduct standard in the first place? The answer lies in the fact that the previous rules governing pension fund benefit administrators were created in 2002. That's over 20 years ago. And think about how much has changed in the retirement industry since then. Technology has evolved dramatically, member expectations have increased, and the complexity of pension administration has grown exponentially. The old board notice 24 of 2002 was simply no longer fit for purpose. It had significant gaps, and it did not address many of the modern challenges facing our industry today. The Financial Sector Conduct Authority, or the FSCA, recognized this problem, and their goal in developing the new conduct standard was really threefold. First, to modernize the regulatory framework to reflect the current realities. Secondly, to introduce the principle of TCF, or treating customers fairly, which is a cornerstone of modern financial services regulations. And thirdly, to close the critical gap in areas like governance, conflicts of interest, complaints management, and data ownership. This is not just a technical update, this conduct standard. It represents a fundamental shift in how we think about pension administration, placing the interest of members at the very center of absolutely everything we do. Wayne will now take us through the consultation process that led to this final conduct standard as we see it today.
Thank you, Geraldine. Now, it's important to understand that this conduct standard did not appear overnight. It was a result of extensive consultation process that spanned several years. The FSCA first published a draft conduct standard in 2023 and invited public comments. The response from the industry was significant. Over 40 stakeholders submitted detailed feedback, including the IRFA, individual administrators, other industry associations, and pension funds themselves. The concerns raised were substantial. Many stakeholders felt that the draft was too onerous, too prescriptive, and would impose unrealistic compliance burdens, particularly on smaller administrators. And here is the good news. The FSCA listened. The final conduct standard, published on 6 August 2025, reflects a genuine effort to balance regulatory rigor with practical implementation. Many of the most burdensome proposals were removed or significantly modified. For example, the 3 million rand capital requirement was dropped entirely. The extensive audit assurance requirements were removed. The framework for apologies, I haven't moved the slide. The frameworks for implementation were extended from 6 to 12 months from 6 months to a phased 12 months. This is a testament to the value of the constructive engagement between the regulator and organizations like the IRFA. The final product is a far more workable draft, far more workable than the draft, and we should acknowledge that. Now, let's highlight 3 specific wins that came out of the consultation process, changes that will make a real difference to how administrators operate. First, the 3 million rand capital requirement was removed. And we need to, sorry, I just want to focus on the responsible key person role was removed, and we'll get back to that a little later. Then the 3 million rand capital requirement was removed. In the draft, every administrator would have been required to maintain 3 million rand in capital at all times. For many smaller administrators, this would have been a significant barrier to entry or even force them out of the market. The FSCA recognized this concern and removed the requirements entirely. Instead, administrators must maintain liquid assets equal to at least 8 out of 12 weeks of annual expenditure, a much more proportionate and flexible requirement. Secondly, or the other aspect is the audit assurance requirements were substantially simplified. The draft included extensive requirements for auditors to provide assurance on various aspects of the administrator's operations. This would have been costly and time-consuming. In the final version, these requirements were removed, significantly reducing the compliance burden. And another element is the timelines that were extended. The draft proposed a single 6-month implementation period for all requirements. Industry feedback made it clear that it's insufficient time. Insufficient time to. It was made it clear that it was not. Let me start again. Apologies. The draft proposed a single 6-month implementation period for all requirements. Industry feedback made it clear that this was insufficient, particularly for updating administration agreements and developing new systems. The final conduct standard introduces a phased approach. Some requirements are effective immediately, others after 6 months, and the most complex requirements, like updating agreements, have the full 12 months in which to be finalized. These changes demonstrate that the FSCA was genuinely listening to industry concerns and was willing to make significant adjustments. That said, the conduct standard still represents a significant step up in regulatory expectations, and compliance will require careful planning and execution. Now I'll hand over to Geraldine to discuss the foundation of the conduct standard, treating customers fairly. Over to you, Geraldine.
Thanks, Wayne. If we can move the slide along there, please. Thanks. We're now getting to the substance of what the conduct standard is about. And we're going to start with, as Wayne said, the foundation, treating customers fairly, or TCF. TCF is not just a slogan or a nice to have principle. It is a required operational mindset that must guide every action an administrator takes. The conduct standard now explicitly requires administrators to conduct their business in a manner that delivers fair outcomes to customers, and in this case, it's the pension fund members. So what does TCF actually mean in practice if we have a look at it? The framework is built on 6 key outcomes, and I'm sure all of us that's here today have heard the importance of TCF. So let us look at the 6 principles that it's based on. So outcome 1 is fair treatment must be central to your company's culture. This means it must be embedded in your values, your policies, and your day-to-day operations. Outcome 2, you must provide clear and timely information to customers. Members should never be left in the dark about their benefits or the status of their claims. Outcome 3, you must deliver services that consistently meet acceptable standards. Mediocre service is no longer acceptable. It's never been acceptable when people's retirement savings are at stake. Outcome 4, you must ensure customers face no unreasonable barriers, whether it's accessing information, submitting a claim, or making a complaint. The process should be straightforward and accessible. Outcome 5, your products and services must perform as expected and meet your customers' needs. If you promise a certain level of service, you must deliver on that level of service. Outcome 6, customers must not face unreasonable post-sale barriers. This includes things like switching administrators or accessing their fund data. The 6 outcomes are not abstract ideals. They are practical benchmarks against which your operations will be measured. The FSCA will be monitoring whether administrators are achieving these outcomes, and non-compliance can result in enforcement action. So, as you think about implementing this conduct standard, always come back to this question. Are we treating our customers fairly? If the answer is yes, you are definitely on the right track. So if we now move to the fit and proper requirements, which is one of the most critical requirements as far as the conduct standard is concerned, and that is that your key persons in your administration organization must be fit and proper. So let us just clarify who must be fit and proper. And this applies to 3 categories of people: your directors of the benefit administrator, your senior managers in key positions, and then head of control functions where applicable. And these are ongoing requirements. They're not a one-time check at registration or once a year. Key persons must maintain these standards at all times throughout their tenure. So if we then look at what does it really mean to be fit and proper, the standard is built on 2 pillars. Pillar 1 is honesty, integrity, and good standing. Key individuals must have a clean personal and professional record. Specifically, they cannot have been convicted of an offense like theft, fraud, forgery, or perjury. They cannot have been removed from an office of trust due to dishonesty. And they cannot have been dismissed or disqualified by a professional body for misconduct. This pillar is about character. The people running pension fund administration businesses must be trustworthy because they're handling other people's retirement savings. If we then look at pillar two is about competence. Key individuals must have the right qualifications and expertise for their specific functions. This means adequate skills, knowledge, and expertise. It means relevant educational qualifications, and it means appropriate experience. This pillar is about capability. It says it's not enough just to be honest. You also need to know what you're actually doing. Now, here's the important part. Administrators must be able to demonstrate that their key persons meet these requirements. This means maintaining proper records, conducting background checks, and ensuring ongoing professional development. If the key person no longer meets this fit and proper requirements, for example, if they're now convicted of a crime or their professional registration is revoked, the administrator must immediately notify the FSCA and then take the appropriate action. This is a very high bar, but it's a very appropriate one. The people managing pension fund administration must be both trustworthy and they must be competent. I'm now going to hand back to Wayne to discuss some of the meat of the conduct standard also as it relates to administration agreements.
Thank you, Geraldine. Now let's talk about administration agreements, the contracts that govern the relationship between the administrator and the fund. The conduct standard requires two types of written agreements. The first, an administration agreement, which is the main contract outlining the services to be provided in terms of the relationship. And second, a service level agreement, which sets out the performance standards and metrics that will be used to measure the administrator's performance. Both of these must be in place before any services are provided. No more informal arrangement or handshake deals. Now, let's look at the 5 key clauses that must be included in every administration agreement. Clause 1, scope of service. This must provide a detailed description of the administration services to be performed and the powers granted to the administrators. There should be no ambiguity about what the administrator is responsible for. Clause 2, remuneration. This must include a clear statement of fees and the basis for calculating all income. Complete transparency on costs is required. Members and trustees have the right to know exactly what they're paying for. Clause 3, data ownership and access. This clause makes it clear that all records belong to the fund, not the administrator. The fund must have the right to access its data upon request within a set time frame, typically 7 days. This is critical for ensuring that funds are not held hostage by their administrators. Clause 4, termination clause. The agreement must include a notice period of at least 90 days. This provides stability and ensures an orderly transition if the relationship ends. No party should be able to walk away overnight. Clause 5, outsourcing rules and remedies. The agreement must address the requirements for outsourcing services and remedies available in case of breach. This ensures that both parties understand their rights and obligations. These clauses are not optional. They are mandatory, and administrators have 12 months from the date of publication until 6 August 2026 to update all existing agreements to ensure compliance. This may seem like a lot of work, but it's worth it. Clear, comprehensive agreements protect both the administrator and the fund, and they ultimately serve the interest of members. Geraldine will now take us through the golden rules of outsourcing.
Thanks, Wayne. And just maybe to let everyone know, there is going to be a recap towards the end where we talk about the timelines as it relates to some of the specifics in the conduct. So outsourcing is a common practice in pension fund administration. Many administrators outsource certain functions to specialist service providers. And the conduct standard recognizes this reality, but it also sets clear rules to ensure accountability is maintained around this. So I'm going to go through the 5 golden rules as far as outsourcing is concerned. Rule 1, the administrator remains accountable. This is the most important rule. Because even if the administrator outsources a function, the administrator still remain fully accountable to the pension fund. You cannot pass the blame if the service provider makes a mistake. In the eyes of the law, you will remain responsible. And this is captured in a very simple principle. You can delegate a function, but you cannot delegate accountability. Rule 2, fund consent is required. Before entering into any outsourcing arrangement, you must obtain prior consent from the pension fund. The fund must be informed and must agree beforehand. There must be no surprises down the line. Rule 3, the provider must be approved. So administration services can only be outsourced to another service provider that is also an FSCA approved Section 13B benefit administrator. You cannot outsource to an unapproved entity. This ensures a consistent standard of competence and compliance across the industry. Rule 4, a written contract is required. Every outsourcing arrangement must be formalized in a detailed written contract that clearly outlines all material aspects of that arrangement. Informal arrangements are not acceptable. Rule 5, ongoing oversight is required. You must conduct regular assessments and reviews of the service provider's performance to ensure continued compliance and quality. Outsourcing does not mean out of sight, out of mind. You must actively manage and continue to do so the relationship. These rules are designed to prevent a situation where administrators outsource functions and then wash their hands from their responsibility. The conduct standard makes it clear. If you outsource, you remain accountable. I'm going to hand back to Wayne, who's going to talk to you about the conflicts of interest.
Thank you, Geraldine. Let's turn to 2 related topics: governance arrangements and conflicts of interest management. First, governance arrangements. The conduct standard requires administrators to document, establish, implement, and monitor the effectiveness of governance arrangements within their organizations. What does this mean in practice? It means 5 things, we think. You must have clear roles and responsibilities for your governing body. Everybody should know who is responsible for what. You must have appropriate segregation of key duties and functions. This prevents conflicts of interests and ensures proper checks and balances. More, you must ensure that key persons have the necessary skills and resources to perform their functions effectively. Then you must have sound remuneration policies that are aligned with customer interests. Incentive structures should not encourage behaviors that harm members. And then, finally, you must have mechanisms to identify and remedy conduct risks before they cause harm. These are not bureaucratic requirements. They are the building blocks of a well-run organization. Now, let's talk about conflicts of interest. Every administrator must adopt, maintain, and implement a formal conflict of interest management policy. The policy must address 5 key areas: how to identify potential conflicts of interest, firstly. You need systems and processes that spot conflicts before they become problems. Then, how to avoid conflicts where possible. The best way to manage a conflict is to eliminate it. Of course, how do you manage and mitigate unavoidable conflicts? Because they exist. Some conflicts cannot be avoided, but they can be managed through disclosure, oversight, and controls. Then importantly, how do you ensure that employees are aware of the policy content? This is where training and communication are essential for the administrator. And then lastly, how do you provide customers with access to this policy, i.e. the pension funds, the boards of trustees? Transparency is key in this. One practical note we thought about is, not we thought about, that the FSC thought about and is included in the conduct standard, is that this policy can be at a group level if the administrator is part of a bigger financial services organization. And you don't need a separate policy for each one of the entities in the financial services organization. Governance and conflicts of interest management are about creating a culture of accountability and transparency. Feeds back to that TCF stuff we spoke about earlier on as well. When these are all done well, they protect both the administrator, the trustees, and the members they represent. Now let's discuss complaints management, an area that is often overlooked but is critically important. Every administrator must establish and maintain an adequate and effective complaints management framework. This framework must ensure fair, transparent, and accessible complaints handling. The process can be visualized in 5 stages. We identified stage 1 as receive and record. Every complaint must be received and recorded in a systemic way. No complaint should fall through the cracks. Then stage 2, categorize. Complaints should be categorized by type and severity. This helps identify patterns and any systemic issues. Stage 3, investigate. Every complaint must be investigated properly and fairly. This means gathering the facts, listening to all parties, and applying the relevant rules and policies. Stage 4, escalate and review. Complex or serious complaints should be escalated to senior management for review. There should be a clear escalation process. Stage 5, resolve. Complaints should be resolved within reasonable timeframes. And complainants should be informed of the outcome and the reason for the decision. The conduct standard sets out 4 specific requirements for complaints management. First, the framework must be easily accessible with no unreasonable barriers for those wishing to complain. Members should not have to jump through hoops to lodge a complaint. Second, all complaints must be investigated properly, fairly, and within reasonable timeframes. Justice delayed is justice denied, they say. Third, complainants must be kept informed throughout the process and must receive clear explanations of decisions. Communication is key. And fourth, comprehensive records of all complaints, investigations, and outcomes must be maintained and monitored and analyzed. This data is invaluable for identifying systemic issues and improving service quality. One important note: dual channels are acceptable. Members can complain either to the pension fund or directly to the benefit administrator. Both channels must be effective. A good complaints management framework is not just about compliance. It's about continuous improvement. Complaints are a valuable source of feedback that can help you identify problems and improve your service. Geraldine will now take us through the data management and financial requirements.
Thanks, Wayne. So the data management and financial requirements are two areas that's essential for the sound operation of any administrator. Data management, if we look at the conduct standard, data management is included in the conduct standard under comprehensive data management requirements for all member and fund data. And it includes provision for third-party data retention with ongoing oversight, minimum retention periods for all records, and data security measures that must be implemented and maintained. But here's the critical principle. All data and records belong to the fund and not the administrator. This is a not negotiable. Data must be accessible to the fund upon request, and it must be efficiently transferred upon termination of an administration agreement. This principle protects the fund from being held hostage by administrators. Your data is your data is your data, and you have a right to access it at any time. Let us talk a little bit about trust and suspense accounts as it's referenced in the conduct standard. Where an administrator make use of such accounts, the administrator must maintain two separate accounts. So if we look at what a trust account is, a trust account is for the deposit of fund monies, whereby money is received on behalf of or used to facilitate payments on behalf of any fund. Where an administrator operates such an account, it must be a dedicated and interest-bearing account that do not form part of the administrator's assets. Where unknown receipts have been deposited into the account, it must be investigated within 2 business days, and if it can't be identified, it must be reported to a senior manager in the admin organization within 30 days. Reconciliations of this must be done on a daily basis and reviewed by a senior manager on a monthly basis. So that's the trust account. Then it also references suspense accounts. Now, a suspense account is for temporary housing of doubtful or unclassified payments until such an amount that was deposited into the account can then be allocated to the correct account. If an administrator receives an unclassified deposit, it must investigate, and if it cannot be allocated, it must be placed in a suspense account and be reported to a senior manager on a monthly basis. The senior manager must report these to the governing body of the administrator on a quarterly basis. And the time frames for these accounts have been adjusted from the initial draft of the conduct standard that came out. So instead of the original proposed 24 to 48 hours, the final standard allows for 1 to 2 business days, which is a far more realistic time frame. If we move on next to the accounting and auditing, administrators must maintain full and proper accounting records that are updated monthly. They must prepare annual financial statements that conform with generally accepted accounting practices. And remember, we're talking here about the actual administrator's business, not the fund's business. Saying administrator must maintain full and proper accounting records that's updated monthly, and the administrator must then also be able to submit annual financial statements. The good news here is that the auditing requirements were substantially simplified from the initial draft that we saw. All audit assurance requirements were removed, significantly reducing the actual compliance burden as far as this part of the conduct standard is concerned. Finally, if we look at the insurance and liability, Administrators must maintain indemnity and fidelity guarantee insurance to protect against losses, and they must maintain adequate liquid assets for financial soundness. This was always part of the old board notice also. The liquidity requirement is straightforward. It is 852s of annual expenditure. So, and that's simple. 852s is you divide that into each other, and it calculates to, I think, about 15.38%. And that is the proportionate requirement that ensures administrators have sufficient resources to meet their obligations. Also to note, the 3 million rand capital requirement that was in the initial draft was removed from the final standard that was issued. And this was obviously a significant win also for the industry, particularly for smaller administrators. These financial requirements, as set out in the standard, it's about ensuring that the administrators are financially sound and operationally capable. And it's there to protect both the administrator and the funds that they serve. So if we now move on and we start looking at, I think, what a lot of the attendees here today would be interested in, the roles and responsibilities of the different parties. So there's really three parties. It's the administrator, the fund or the trustees, and the Financial Sector Conduct Authority. So I'm going to kick off with the trustees. So trustees have a fiduciary duty to ensure that the funds administrator complies with the conduct standard. Active oversight is essential to protect the members' interest. So what do trustees need to do? Is really 8 key principles that trustees would need to apply to actually adhere to this. So firstly, they need to verify that the administrator is an FSCA approved administrator. So under Section 13B of the Pension Funds Act, such approval needs to be obtained. And this is a basic but critical check. You should not be working with an unapproved administrator. Secondly, the trustees review and sign a compliant administration agreement. Make sure your agreements include all the requirement clauses and protect the fund's interest. Don't just sign on the dotted line. Read the agreement carefully and ask questions if anything is unclear. Thirdly, give consent to any outsourcing arrangements. Very important. Before your administrator outsources any of its functions, you must be informed and you must consent to it. And you should verify that the service provider that the administrator is outsourcing some of its services to is also an FSCA approved administrator. Fourth, monitor your administrator's performance. Regularly assess whether the administrator is meeting the service standards and compliance requirements as expected. And this is not a set it and forget it type of relationship. You need ongoing oversight. Fifth, you understand the complaints channels. Make sure members know how to submit complaints and that the complaint framework is effective. You should be receiving regular reports on complaints and how they are being resolved. 6, verify data ownership rights. Confirm that all member records belong to the fund and are accessible within agreed timeframes. This is your data, and you have the right to that data. 7th, review the conflict of interest policy. Wayne spoke about that conflict of interest policy earlier on. Request access to this and review your administrator's conflict of interest management policy. Make sure it is robust and it is being implemented effectively. And lastly, the 8th one, check insurance and liquidity. Verify that your administrator has appropriate indemnity insurance and maintains the required liquid asset requirements at all times. Remember, the conduct standard says those liquidity requirements must be met at all times, not just once a year. These are very important safeguards. But the trustee's role is not a passive one. Trustees are the guardians of members' interest, and you as trustees have the duty to ensure that your administrator is operating in compliance with the conduct standard. If you have concerns, raise them. If you need information, ask for it. Active oversight is absolutely essential. So if we now look and we move on to the administrator's responsibilities as far as the conduct standards is concerned. If you're an administrator, you do have a long list of responsibilities under the conduct standard. I'm going to walk you through the key items on what should be on your compliance checklist. First, comply with all requirements of the conduct standard. They're not negotiable. You have to comply to them. Implement documented governance arrangements. Ensure key persons meet fit and proper requirements. Update and create compliant administration agreements. Establish an effective complaints management framework. Implement a conflict of interest management policy. Ensure data management and record keeping compliance. Maintain financial soundness and operational ability. Notify the FSCA of changes in business information. Submit your financial statements to the FSCA. Manage your outsourcing arrangements with ongoing oversight. Maintain your liquid assets equal to or greater than 8 out of every 52 weeks of annual expenditure. Ensure you've got adequate indemnity and fidelity guarantee insurance in place, and maintain trust and suspense accounts properly. This is a comprehensive list, and in case you were trying to jot it all down, remember, as Wayne said, these slides will be made available. And the list, it might also feel overwhelming, but here's the key message. Compliance is ongoing. It's not a one-time exercise. You cannot simply tick these boxes and move on. You need regular monitoring, continuous improvement, and adaptation to changing circumstances. My advice is to break it down into a manageable project. Use the phased implementation timeline to your advantage. Focus on the immediate requirements first, and then move on to the 6-month and then the 12-month requirements. And remember, don't try and do it alone. Engage with your legal advisors, your auditors, your IT team, and your governance specialists. This needs to be a team effort. And finally, remember, the goal here is not just compliance for compliance sake. The goal is to operate a high-quality, member-focused administration business that treats customers fairly and delivers excellent service. If you keep that goal in mind, compliance will follow naturally. I'm now going to hand over to Wayne, who will now talk about the third role, and that is that of the FSCA as our regulator.
Thank you, Geraldine. Let's have a look at the FSCA's role. The FSCA essentially has 9 key responsibilities. And I'll start. The first is supervise compliance. The FSCA will monitor and supervise benefit administrators' compliance with all requirements of the conduct standards. This is their core regulatory function. Second, they'll receive notifications. Administrators must notify the FSCA of changes in business information and key persons. The FSCA will receive and process these notifications. Third, review financial statements. Administrators must submit annual financial statements to the FSCA, and the FSCA will review them to assess financial soundness. Fourth, determine forms. The FSCA has issued RF Notice 10 of 2025, which determines the format and manner of the submissions. This ensures consistency and makes it easier for administrators to comply. Fifth, approve administrators. The FSCA approves and registers benefits administrators under Section 13B of the Pension Funds Act. This is the gateway to operating legally. Six, take enforcement actions. If an administrator fails to comply with the conduct standard, the FSCA has the power to take enforcement actions. This can include fines, directives, or undertakings, or even deregistration in the worst case scenario. Seventh, provide guidance. The FSCA will provide guidance and clarification on the interpretation and application of the conduct standard. If you are unsure about a requirement, you can seek guidance from the FSCA. Eighth, monitor TCF outcomes. The FSCA will monitor the achievement of the TCF outcomes across the industry. This is about ensuring that the principle of TCF is being translated into practice. And ninth, and the next big thing we're going to all face, oversee the COFI transition. Looking ahead, the FSCA will oversee the future transition of the conduct standard into the COFI framework. This is part of a broader financial sector reform agenda. One important note, all conduct standard documents are available on the FSCA's website. If you haven't already, I encourage you to download and review the full text of the conduct standard and the accompanying documents. The FSCA is not an advisory body. They are the regulator, yes, but their goal is the same as ours, to protect pension fund members and ensure a sound, fair, and efficient retirement system. If you approach compliance in good faith and engage constructively with FSCA, you will find them to be reasonable and supportive. Now let's talk implementation. One of the most important changes to the draft, from the draft to the final conduct standard, was the introduction of the phased implementation timeline. The conduct standard is being implemented in 3 phases. Phase 1 is immediate, effective from 6 August 2025, the date of publication. This phase includes business principles and TCF, fit and proper requirements, financial matters like accounting, auditing, and insurance, liquidity requirements, and notifications to the FSCA. These are existing requirements that the administrator should already be meeting and can implement relatively quickly. Phase 2 is 6 months after the publication, effective from 6 February 2026. This phase includes governance arrangements, conflicts of interest management policy, complaints management framework, data management requirements, and the operational procedures and controls. These requirements involve developing new policies, frameworks, and procedures, which take some time. Phase 3 is 12 months after publication, effective from 6 August 2026. This phase includes administration agreements, service level agreements, and outsourcing arrangements. These are the most important requirements because they involve updating existing agreements with multiple pension funds and formalizing outsourcing arrangements. If the administrator administers a large number of funds, the 12-month timeline really recognizes this complexity. Now, you might ask, why the extended periods? The answer is simple. industry feedback indicated that 6 months was insufficient for systems development and updating agreements. The phased approach allows thoughtful and effective implementation rather than a rushed tick box exercise. My advice is to use this time wisely. Don't wait until the last minute. Start planning now. Identify what needs to be done, allocate resources, and set internal deadlines that are earlier than the regulatory deadlines. This will give you a buffer in case things take longer than expected. And remember, the FSCA is monitoring compliance. They will expect to see evidence that you're making progress, not just scrambling at the last minute. Geraldine will now summarize the key takeaways from today's session.
Thanks, Wayne. I'm sure everyone is starting to suffer a bit of brain drain here, but we are approaching the end of today's webinar. I'm going to summarize the 8 key takeaways that you should remember from today's webinar. Takeaway 1, modernization. The old 2002 rules have been updated for today's environment, incorporating modern principles and closing some critical gaps. This is necessary and overdue reform. Takeaway 2, fairness at the heart. Treating customers fairly is the foundation of this conduct standard. Fair treatment of pension fund members must guide absolutely every action you take. Takeaway 3, clear roles and responsibilities. The conduct standard sets out specific requirements for administrators, trustees, and the regulator, the FSCA. Everyone knows what is expected from them. Takeaway 4, accountability cannot be delegated. Administrators can outsource their functions, but they remain fully accountable to the fund. You can delegate work, but you cannot delegate responsibility. Takeaway 5, better protection for members. The conduct standard offers stronger governance, fit and proper requirements, complaints frameworks, and data management. And this all serves to protect the pension fund members. This is ultimately what everything is about. Takeaway 6, balanced and practical rules. The FSCA listened to what the industry feedback was, and major burdensome proposals were removed. The final standard is a workable and proportionate document. Key takeaway 7, phased implementation. Extended transitional periods give administrators time to comply thoughtfully and effectively. Use this time wisely. And takeaway 8, ongoing compliance. This is not a once-off exercise. Continuous monitoring, adaptation, and commitment to fair outcomes are absolutely essential. The new conduct standard represents a significant way forward for the South African retirement sector. It creates a stronger, fairer, and more consistent regulatory framework that ultimately protects pension fund members. Yes, it will require some effort to implement. Yes, it will raise the bar for administrators, but it is the right thing to do, and it will make our industry better. I think we've now reached the Q&A portion of our webinar. I believe we do have some time, and this is really your opportunity to ask questions, share concerns, or discuss your experience with implementing the new conduct standard. And remember, as always, the IRFA is here to support the sector through this transition, and we do want to hear from you. Wayne, I saw that we have got some questions coming up in the Q&A. I saw, Angus, I saw your first question. Isn't your outcome 4 and 6 the same? The slide seems to have left out ensuring appropriate advice. I think you could very well be correct. I don't know if we can just maybe in a minute have a look at that slide, Wayne. If we could just have a look. I just want to go to Angus's second question, because this is a very important one, and I'm sure a few people would like to comment on it. Angus is saying, any thoughts on the impact of having both the administrator and the fund being responsible for member outcomes and complaints handling, i.e. the administrator and the fund? And I think that is pretty spot on, Angus, because this is just my opinion. I thought about it, in fact, yesterday when I went through the conduct standard again. And I think sometimes, in my opinion, it is a bit of a blur, because your administrator deals with the complaints on behalf of the fund, and like that C2TCF. However, your fund, as your trustees, have actually needs oversight of how complaints are being dealt with, and should it then not be a collaborative manner in which it is handled. I'm not going to say any more there. I'd like to hear whether there's anyone else that would like to add something. Maybe Angus wants to jump in, or I don't know if Nancy is online. Nancy, if you, Wayne, anyone wants to jump in on this point? Because I think it is a very important one and a very valid question. Wayne, have the attendees got ability to speak?
We haven't enabled that, unfortunately, so it will have to be a written response. Yeah.
Okay, so sorry about that, Angus. I thought I'm going to be able to enter into it later with you. So I think what we will then have to do is we'll have to respond post the webinar. Is that how you want to handle it, Wayne?
Yes, please.
Okay, then Francois asked, will the recording of the presentation be shared?
Yes.
Yes, that will definitely be shared. The recording and the slides will be shared, Francois. Then we've got Dylan. Is the suspense account still required where there will be no unallocated amounts post 3 business days? Wayne, I don't know if you wanted to answer, but my understanding is only if you can't reconcile and allocate the amount to a correct account, then does it need to move to the suspense account. So in effect, your suspense account won't be required if you are going to move it from where it was deposited into before the 3 business days. Wayne, I don't know if you wanted to add there.
No, Geraldine. I just think the conduct standards clear on the timelines, and adherence to the timelines would be what you need to work towards. And yeah, if you can explain it.
I just wanted to, I'm fairly certain of that, Dylan. I mean, any of our legal experts can disagree with me, but my practical mind tells me if we're going to move the money out of wherever it was deposited to, if we can identify it and allocate it to where it should go within the 3 business days, you don't actually then need a suspense account, because you don't need to then move the money into this suspense account. The next question from Jaya. How are you thinking about outsourcing within a group of companies? Many large administrators are part of a large group of companies. where all employees are employed by one of the companies in the group and everything is effectively outsourced by the administrator to the company in the group that employs the employees. Wayne, Jaya, I mean, it's really a pity Nancy can't answer because answer live, because I know this was a debate in the IRFA legal and technical work group. It was one of the debates that they had. Wayne, I don't know if you can recall the actual outcome of the discussion.
The short answer is yes.
Mm.
Yeah. And
Okay, so effectively, okay, let's just recap. Is
yeah.
yeah.
So if a company, for example, has two administration licenses, and they outsourcing from company A to company B, that is effectively an outsourcing. And I mean, this really relates to administration functions. And that is the feedback we had. I think Nancy can answer, but that's the bottom line from that conversation that was had around this point.
Thanks, Wayne. Do you want to run through the next question?
Do you know how the FSCA will monitor compliance up until the end of the 12-month period? What will the continuous monitoring look like? No, we can't respond on behalf of the FSCA, but I do think the monitoring will be through the regulatory submissions that need to be made on a regular basis, as set out in the conduct standard. I don't know, Geraldine, if you've got anything to add there.
Yeah, I think if I look at the question, do we know how the FSCA will monitor compliance up until the end of the 12-month period? I believe it will be through engagement sessions. We've already seen them starting to happen, Wayne. I'm aware that, and I've seen some of the agendas around these engagement sessions, and a lot of that is for the FSCA. If I gauge the agendas for them to start getting a feel of what the administrators actually have got in place, how have they kicked it off, having a look at what they do have in place. And I think really a guidance role. I mean, as we've seen with this conduct standard, which is really the result of the conduct standard follows a very collaborative approach that was taken between industry and the regulator and stakeholders. And I think, again, that, the FSCA has shown us, it's as Wayne said, they're not, the FSCA is not an adversary. They're here, they want to engage. And I believe that is how they will deal with it in the next 12 months. Thanks. I see Dylan said understood. Wanda, this is actually an observation. Seeing as administrators can delegate work but not responsibility to their service providers under the conduct standard, one notable takeaway for me is for administrators to be more mindful and pedantic with their own contracts, with their service providers on both preventative and consequent management fronts going forward. 100%. I agree with you, Wanda. Wayne, I don't know if you want to add something, but certainly from my view, yes, you're going to have to make sure your contracts with your outsourced providers are really sharp and up to scratch. Wayne, do you want to move these, Angus?
Had another question.
Okay.
Large financial services product, large financial service product and providers will have a broad governance and compliance framework in place. Do they need to add these to make them specifically deal with the services or administering retirement funds to be in compliance with the conduct standard requirements? Geraldine, I don't know if you want to go for it, but my answer and my thought
Yeah,
would be yes.
yeah. Angus, I believe yes. I'm trying to think where I read it, and I think it could actually very well be in the conduct standard where it specifically says it could be on group level, but your policies would need to be adapted to specifically bring in the requirements of the conduct standard.
And then thank you, Geraldine, and I agree. And I think there's Fiona's Fiona Rollison's comment around outsourcing. You need to look carefully at what services are being done by the other companies in the group. And if any of them are doing admin services, that is outsourcing. I think it just reaffirms the point we had earlier when we were speaking, responding to Jaya's query.
Yeah.
Magda Brits. All right. May we share the slides with boards of trustees? Thank you for your presentation. Okay. Yes. Happy that the whole aim was for us to create something that was hopefully useful enough to be a guide going forward. And then Angus, another query. I think it just relates again to specificity around large financial services organizations that administer retirement funds as well, and whether it can be incorporated into, or it can be used without any adaptation or changes for the pension administration business. I think consult the conduct standard again. My gut is that if it's not compliant with the conduct standards requirements, then you'd have to review and align it with the conduct standards requirements. Geraldine, I don't know if you've got any other observations there.
No, I think that covers it.
You want to grab Cheryl's one? Shall I read it for us and then see?
Yeah, if
Cheryl
you
Grant.
say,
Sorry, go for it.
yeah. No, carry on, Wayne.
Um, if you say that the key persons need to be qualified, what does this mean in reality? An applicable qualification for the head of operations, for instance. Otherwise, they don't comply regarding this requirement. I'm going to hand that right back to you, Geraldine. It's your.
Thanks. Cheryl, I think, a key person doesn't need to necessarily have an MBA, but the key person that runs a administration business must first of all, be qualified to. It must be. I would attach the word appropriate to it because you need to have some business management skills. Obviously, if you a director or a key person, but for me, the fundamental would be to have qualifications and understand our industry, and again, when you think about appropriate, it's someone with an MBA and a certification in forestry. The MBA and the certification in forestry is not going to. Is that appropriate? No, because your MBA is not going to tell you about our industry. So I think it is. To me, it would be an assessment. Certain broad parameters needs to be met, and then from there, an assessment on a case-to-case basis. I hope that answers your question, Carol.
Want to see if,
And then just may slides be shared again.
yeah.
I think we run through all of them, Wayne?
Yes, I think there's just one more comment from Angus, and we can just leave it. Just a comment.
Oh,
Maybe the most elegant fix is to add a 13B administrator specific annexure to the financial institutions
yeah.
board governance complaints. Yes, that's a great.
Yeah.
Yeah.
I think you're spot on there, Angus. I think that is what is going to happen. As Wayne was running through some of the others, I tried to find the specific paragraph where I actually saw something on it, but there is definitely something, and I think a 13B specific annexure would solve that issue.
But again, at the end of the day, and we're going to finish that off, we'll probably kill off, we've had a good session, is that, the board must be able to access it and be able to understand it. For me, if I was the board of trustees, if any of these agreements or arrangements being presented to me, I'd want them to be in a language and in a format that's understandable to me, so that I can exercise my fiduciary duty appropriately.
Yeah.
Think I'm maybe just mentioning that because of the complexity sometimes of some of the large organizations' policies and
Mm,
frameworks.
mm.
Yes, thank you.
Okay, I think that brings us to the end, Wayne.
It does indeed.
You're going to close off for us. From our side, I just want to thank everyone for taking the time to spend with us. I trust that was informative and helpful. I always say, as I think something is simple and I finally understand the ins and outs of it, one of our clever pensions lawyers will throw a spanner in the wheel and come up with a technicality, and which always reaffirms why we need them, hey? But in any event, I've got no doubt that there's going to be many questions that come about for all of us out of this as we start living the document. But yes, I think it's an important part of where we've gone. We've seen extensive regulatory reform in our industry in the last 10, 15 years, and I think this was about time that this happens. We all keep on saying that the most important party in this business of ours is the member, and ultimately this is for the protection of the member. Wayne, so that is it from
Thank you.
me.
Yes, and thank you for supporting us in this, and hopefully it's a tool that's useful to all of you. And I think it's also our one of our steps towards the the introduction of Kofi, and getting our minds ready for that big shift, our next big step. But thank you for attending, and the video or the recording will be available to the attendees as well as the presentation. Just a reminder. Thank you everyone for making the time.
Wayne, sorry, and will that be on our website? Is that where they access it?
Yeah, we'll send a link. We'll be
Okay,
recording it, yeah,
thank you.
and we'll share it via a link. Thank you. Thanks, Jeremy.
Super.
Thanks everyone. Thank you for attending. Bye bye.
Thanks, bye bye.